Well, good afternoon, everybody. Thought we'd carry on with the next part of Michael Cicchini's excellent article looking at prosecutorial misconduct in closing arguments. I mean, it's all so poignant, but again, you'll see exactly why this next section is so important. So this is for the Oklahoma Law Review, as I say, by Michael Cicchini, a great friend of this channel, and he sent me this last week. So section E, vouching and personal opinion. Vouching is likely the most common form of improper argument, but its numerous variations can make it difficult to identify. In general, a prosecutor vouches when he or she gives a personal opinion about the defendant's guilt or about a particular piece of evidence. This can be problematic, as research consistently shows that jurors inherently find prosecutors to be more credible than defense counsel. Therefore, it is improper for a prosecutor to express a personal belief in the guilt of the accused or in the veracity of the state's witnesses. Although it occurs with some frequency, most courts conclude that it is misconduct for prosecutors to make I statements such as I think or I believe. Some obvious examples of such blatant vouching include I think the defendant is guilty, or I believe the victim testified truthfully. Some courts will let prosecutors get away with vouching. However, if the I think or I believe statements are properly disguised, let me start that again. Some courts will let prosecutors get away with vouching. However, if the I think or I believe statements are properly disguised, examples might include I think the evidence in this case shows the defendant is guilty, or I think the physical evidence proves the victim told the truth. Therefore, whether this type of argument is improper depends on how the language is parsed. In most cases, prosecutors express their personal opinion of the defendant's guilt indirectly by giving their opinion that the government's witnesses testified truthfully and therefore the jury should believe them. Wow. Remember Ken Kratz going on about Bobby Dassey. Prosecutors indirectly vouch for many types of government witnesses, but they most commonly do so for the police. That is, prosecutors make inappropriate attempts to persuade the jury that the police officer's testimony should be believed simply because the witness is a police officer. While offering a personal opinion is by itself improper, many prosecutors compound this offense by bolstering their opinions with references to matters outside of the record. One prosecutor, for example, bolstered his personal opinion of the defendant's guilt by explaining to the jury, I look up police reports. I determine whether I believe a person is guilty and whether I think it's just. I also have the discretion to dismiss the charges if I think they're unjust, if they didn't happen, if it's not provable. While vouching for several police officers, another prosecutor argued that the police witnesses must be believed because before they can become police officers, they take oaths to follow the law and so do not stick people with charges. The prosecutor specifically argued that during their induction ceremonies, Officer Gammon took an oath to uphold the laws, and Detective Arkins took the same oath. Therefore, in order to acquit the defendant, the prosecutor contended the jurors would have to believe these police witnesses consciously violated their oaths as well as their oaths at trial and lied on the stand. Such vouching, especially when based on facts, not in evidence, constitutes misconduct by the prosecutor. Item F, prosecutor testimony. When prosecutors aren't vouching for the state's witnesses or evidence, they sometimes offer their own testimony, thus creating evidence out of thin air. How do I get the impression he's talking about Kratz in every single paragraph? Although the law is clear that counsel has no right to create evidence or to misstate the facts, and that any argument on matters not in evidence is improper, prosecutors often testify in closing argument nonetheless. The most egregious example of prosecutor testimony occurs when a prosecutor argues facts that he or she knows to be false. For example, in one case, a prosecutor argued to the jury that the defendant never denied committing the crime until he got on the witness stand. This might have been a proper argument had there been evidence at trial of the defendant's pre-arrest and pre-Miranda silence. But in this case, the prosecutor knew better because she had two different police reports detailing how the defendant had denied committing the crime long before he took the witness stand. The argument was therefore improper, as prosecutors may not ask jurors to draw inferences that they know or should know are not true. In other cases, prosecutors argue facts that might be true but prevent the introduction of evidence proving or disproving the facts and deny defense counsel the opportunity to challenge the facts by waiting to discuss them until closing arguments. This tactic violates both due process and the right to confrontation. Testimony from a prosecutor is difficult enough to overcome, but it is impossible for a defendant to test or counter a prosecutor's testimony when the defendant is denied his right to confront the prosecutor as a witness. In one example of this tactic, a defendant testified he was out of town at the Luxor Hotel in Las Vegas at the time in question. Instead of presenting contrary evidence at trial, the prosecutor waited until closing argument and testified that he knew the defendant was not at the Luxor because the prosecutor said, "I was able to have members of my staff telephone the Luxor," thus implying that the defendant had lied. In a different case, one alleging child sex assault, a prosecutor argued that because the defendant had been sexually abused herself as a child, she was more likely to have committed the alleged sexual assaults in this case. This prosecutorial testimony was a twist on the battering parent syndrome, but was improper because it was unsupported by expert testimony at trial. The above examples are relatively easy for defense counsel to recognize. Sometimes, however, prosecutors do a better job of disguising their factual assertions as argument. For example, one prosecutor argued that the defendant in a drug case was able to post his $10,000 bond because he could go out the next day and make $10,000 up on one transaction. This was improper because during the evidence portion of trial, the prosecutor did not even attempt to prove the defendant had received any money as a result of any drug deals, not even the alleged delivery with which the defendant was charged. In another case, a defendant was charged with arson and the government had seized his clothing to test for gasoline. Defense counsel properly argued that the test came back negative, thus pointing to the defendant's innocence. The prosecutor, however, responded by speculating that the reason for the fact could be that the defendant had destroyed the clothes he wore when committing the crime. The court held that such argument was improper because it suggests a course of conduct by the defendant for which there was no evidence in a closely related tactic. Prosecutors may instead misuse a piece of evidence that was presented at trial. One amazingly creative prosecutor, for example, argued that a defense witness's prior conviction, a conviction admitted into evidence only to impeach that witness's credibility, was somehow evidence that the defendant was guilty of the crime for which he was on trial, regardless of whether the prosecutor is creating evidence out of thin air or misusing real evidence that was introduced at trial. Both forms of argument are prejudicial and improper. Item G, misstating the law. Applying the law to the facts of the case is proper argument. Misstating the law when doing so, however, is not. Prosecutors have misstated nearly every imaginable legal standard, including the law of affirmative defenses and of lesser included crimes. But the height of sophistry can be found in prosecutors' misstatements of the burden of proof. Prosecutors commonly attempt to lower the government's burden of proof, thus raising the odds of winning a conviction. For example, one Washington prosecutor argued that the jury's duty in reaching its verdict was to search for the truth. The appellate court, however, rightly stated that this argument misstates the jury's duty and sweeps aside the state's burden. Or, as one federal court explained, seeking the truth suggests determining whose version of events is more likely true, the government's or the defendant's, and thereby intimates a preponderance of evidence standard. Similarly, a California prosecutor argued that the reasonable doubt standard is one you use every day in your lives when you make important decisions, including decisions about whether you want to get married. The appellate court, however, held that such a statement trivializes the reasonable doubt standard. Further, the marriage example is also misleading, since the decision to marry is often based on a standard far less than reasonable doubt, as reflected in statistics, indicating 33 to 60% of all marriages end in divorce. To make matters worse, these misstatements of law are sometimes incorporated into the trial judge's instruction to the jury on reasonable doubt. In Wisconsin, for example, the often challenged pattern jury instruction uses both the analogy of decision-making in the important affairs of life and, worse yet, literally instructs the jury not to search for doubt, but instead to search for the truth, regardless of whether the prosecutor's argument parrots the trial judge's instruction. However, arguments that falsely attempt to lower the burden of proof are still improper. Returning to the previous examples from Washington, the appellate court found that the prosecutor's argument to search for the truth improper, despite the court's pattern jury instruction equating beyond a reasonable doubt with an abiding belief in the truth of the charge. Similarly, in California, the appellate court found the prosecutor's argument equating proof beyond a reasonable doubt to everyday decision-making in a juror's life improper, despite the trial judge's instruction to the jury to do the same. Prosecutors also seek to diminish the burden of proof by presenting the jury with a false dichotomy. In order to find the defendant not guilty, you would have to find that the state's witnesses are lying about the evidence they presented to you. It's really that black and white. Well, is that not just like you have to believe your cops killed Teresa. Of course, such arguments suffer from two fatal flaws. First, testimony may be in direct conflict for reasons other than a witness's intent to deceive, the most obvious of which, of course, is that a witness may merely be mistaken. And second, such prosecutorial arguments actually sidestep the burden of proof itself. It, of course, does not follow as a matter of law that in order to acquit the defendant, the jury had to believe that the agents had lied. If the jurors believed that the agents probably were telling the truth and that the defendant probably was lying, it would have been proper to return a verdict of not guilty, because the evidence might not be sufficient to convict the defendant beyond a reasonable doubt. To tell the jurors that they had to choose between the two stories was error. In other cases, instead of merely lowering the burden of proof, prosecutors often try shifting it to the defendant, regardless of whether the defendant presented evidence at trial. Just as prosecutors can spin a defendant's decision to testify or to remain silent into evidence of guilt, so too can they spin the defendant's entire defense. When the defendant decides not to present any evidence and instead attacks the strength of the government's case, prosecutors have shifted the burden by asking the jury, how many witnesses did the defense put on for your consideration? Conversely, when the defendant decides to call witnesses, prosecutors have shifted the burden by improperly arguing that the defendant has the same responsibility as the government and that it is to present a compelling case. Finally, another prosecutorial twist simply asks the jury to dispense with the burden of proof altogether, arguing that the burden of proof beyond a reasonable doubt is a shield for the innocent, not a barrier to convict for the guilty. Therefore, the argument continues, because the jury knows the defendant is guilty, it should automatically convict, even when the prosecutor is technically unable to prove it. Wow, this is getting good. This is so much Ken Kratz, isn't it? Eh? H, straw man. When a prosecutor sets up a straw man, he or she makes an argument, attributes that argument to defense counsel, and then demonstrates that the argument is invalid. Thus, the prosecutor gives the impression that because he or she clearly won the debate, the jury should convict. The point that often eludes the jury, however, is that the prosecutor was merely arguing with him or herself. A common version of a straw man argument tracks closely with the false dichotomy prosecutors use to diminish the burden of proof. For example, when a defendant argues that a police officer was mistaken in his or her identification of the defendant as the perpetrator, prosecutors will often distort the argument. While defense attorneys try and say, well, we're not saying the police are lying, what else are they saying? There's no other reasonable explanation, and it kind of frustrates me knowing and working in this field and knowing these officers, and you know them now too. You know them. They work hard. They do a tough job. They come in here to testify a lot of times. They work long hours. You weigh their testimony against the defendants. Fortunately, the appellate court saw through this argument. We cannot ignore the prosecutor's self-imposed frustration at his own suggestion that testifying police officers may have lied. That is, defense counsel never once suggested the officers were lying, rather the prosecutor merely created a straw man. But once the prosecutor's rhetorical straw man was created, it had to be eliminated. And the prosecutor eliminated it by referencing matters not in the record and by vouching for the credibility of the police witnesses, both of which prejudiced the defendant. When straw man arguments are made in the prosecutor's first argument to the jury, it is possible, though time-consuming, for defense counsel to simply expose this sophistry in his or her own closing argument. But when the prosecutor sandbags defense counsel by making this improper argument in rebuttal, then the trial judge may have to be called upon to cure the prejudice. Let's go for one more section because I'm really enjoying this. And so is John. Isn't that right, John? Yeah, of course. I, sweet emotion. A prosecutor is not permitted to ask the jury to convict the defendant for any reason other than proof beyond a reasonable doubt. Nonetheless, prosecutors often resort to improper emotional appeals to win convictions. The countless examples of this type of prosecutorial misconduct make it impossible to catalogue them all here. There are, however, three types of emotional arguments commonly made by prosecutors: invoking sympathy for the alleged victim, instilling fear of the consequences for failing to convict, and pandering to juries' biases and prejudices. With regard to sympathy-based arguments, prosecutors often attempt to win a conviction by pitting the alleged victim against the defendant. In one case, at the conclusion of the prosecutor's closing argument, he urged the jury to show the defendant the same mercy shown to the victim on the day of her death. In other cases, prosecutors will whip up even more emotion by asking the jurors to step into the shoes of the alleged victim. For example, one prosecutor made an objectionable golden rule argument stating, "It's a gun, it's a real gun, it's a gun with a laser on it. Just imagine how terrifying this laser would be if it was on your chest." Equally dangerous is the prosecutorial argument that invokes fear in the context of societal issues. That is, prosecutors often urge jurors to convict because of what will happen to society if they acquit. For example, one prosecutor urged the jury to convict the defendant of a drug crime, not based on evidence, but because drugs are corrupting our society. Drugs are destroying our children. You must consider the significance of what we are talking about. As the previous example demonstrated, children are an especially useful tool for invoking fear in the jury. Another prosecutor argued that the jury should convict not because there was evidence the defendant committed the child sex crime with which he was charged, but rather to prevent hypothetical future crimes. I don't know how many more small children we are going to allow him to. Hitting even closer to home, another prosecutor urged jurors to convict a defendant in order to send a message to those folks who might want to molest your neighbor's children, your own children, or grandchildren. Despite the effectiveness of using children to instill fear in a jury, perhaps the most effective way to invoke fear is to argue that the jurors will personally be put in harm's way if they acquit the defendant. In a not so subtle example of this argument, one prosecutor told the jurors, "That gun is still out there. If you say not guilty, the defendant walks right out of the door, right behind you." Finally, in addition to invoking sympathy and fear, prosecutors may also improperly rely on deeply ingrained racial and class biases to win convictions. For example, one prosecutor argued that a jury should convict a Jamaican defendant because what is happening is that Jamaicans are coming in, they're taking over the retail sale of crack. It's a lucrative trade. The money, the crack, the cocaine that is coming into the city is being taken over by people just like the defendant. And biases can run in both directions. Another prosecutor improperly argued that if the jury failed to convict the defendant, she was rich and would thumb her nose at small Martin County and say, "Well, we really pulled one over on those guys." Let's hold it there. That was absolutely fantastic reading. Michael Cicchini's article there for the Oklahoma Law Review. At about 11 o'clock my time, that's 5 o'clock Wisconsin time, 8 o'clock in the morning for the HOD. I've got a chat with him, premiered. But I'm really enjoying reading Michael Cicchini's article here. It really does. I think just every single thing he says, we can look at Making a Murderer and see exactly the same things happening to Stephen Brendan. Anyway, I'll catch you all again soon. Take care. Bye for now.